Debt Collection Overview. You have been served with a debt collection lawsuit. That is not a small claims action. Now what? In order to enforce payment of a debt, a plaintiff must first file a lawsuit and obtain a judgment. This lawsuit can be personally served on you, the defendant. You can also be served by substituted service, whereby one copy of the lawsuit is left with an adult at your home or place of business. If service is attempted several times without success, a plaintiff can obtain a court order to serve you by placing notice in a locally approved publication. Once personally served, you will have 30 days to respond to the lawsuit. If served by substituted service, you have 40 calendar days from the date the second copy was mailed to you to file a response. Failure to respond to the lawsuit will result in a default judgment. A default judgment means the plaintiff will be granted an order from the court allowing for the full amount sued for. So, if the plaintiff sues you for $5,000, they will obtain a court order for $5,000. This amount may increase if the plaintiff asks for attorney fees and/or costs. Depending on the type of judgment, generally a judgment expires after 10 years but can be renewed by the plaintiff before it expires. Furthermore, interest will accrue on the judgment amount. How can the plaintiff collect on their money order granted by the court? Plaintiff can collect in different ways, including by bank levy, wage garnishment, and property liens. A lien is a kind of security interest like a mortgage. It allows the plaintiff holding the judgment to get paid if your house gets sold or refinanced. A bank levy allows the plaintiff to go into your bank account and take the money needed to satisfy the debt. A wage garnishment allows the plaintiff to garnish up to 25% of your post-tax wages. There are certain monies exempted from a wage garnishment or bank levy. More on this later. The first question you should ask yourself is, should I answer the lawsuit? If you don't owe the debt you are being sued on, or have a defense as why you shouldn't pay it, then you should answer the lawsuit. Even if you do not think you have a defense, you can still file an answer to prevent a default judgment. Filing an answer can provide you with more time to consider your options in the case. If you do not have assets, have little income, or have protected income like SSI or SSDI or some other government benefit, and you do not anticipate your financial situation improving, you may be collection-proof and might choose not to answer and should communicate your situation to the plaintiff via letter or phone call. It is best to consult with an attorney or attend the free workshop to obtain more information on being collection-proof. Please note that the plaintiff can still proceed with the lawsuit and obtain a default judgment against you. If you do opt to file an answer, be aware you have 30 or 40 calendar days depending on how you were served to respond from the date you were personally served and not from when the complaint was filed. Calendar days include weekends, so be sure to calculate the number of days correctly and err on the side of caution to avoid a default judgment. There is a fee to file your answer with the court. Please refer to the court website for current court costs. If you are experiencing financial hardships, you can complete a request for a fee waiver form FW-001 and also complete the order for fee waiver form FW-003. You can download these forms for free at the court website. You can file these documents along with your answer at the same time. Now that the court fees are settled, you can answer the lawsuit using Answer Contract, Form PLD-010. Please refer to the next video on answering forms for further instructions. The final form is the Proof of Service, Form POS-030. This is an affidavit filed with the court under penalty of perjury signed by your process server. You cannot serve your own papers if you are a party to the lawsuit. This means that you have to have someone else serve the papers and fill out and sign the proof of service. Remember, the proof of service is the document you file to let the court know that your answer has been sent to the plaintiff. The following video will provide further instructions. Proof of service needs to be completed and filed with your answer through the court. Once you have filed with the court, you are now in litigation. It is important to attend all court hearings and respond appropriately to any discovery requests. Your first hearing may be a status conference. A trial date will be set at this hearing. Be sure to attend and listen for your case to be called. Once called, you will need to identify yourself. For example, USA Bank versus John Doe. You will say, I am defendant John Doe. The judge will then set a trial date. Failure to attend a hearing, or to timely respond to any discovery requests sent from opposing counsel, can have negative consequences for your case, including possible sanctions or fines, or have certain facts admitted, and therefore possibly losing your case without a trial. Therefore, Do not ignore any correspondence in the mail either from the court or opposing counsel. Should you receive any correspondence and are unsure how to respond, please contact the court's self-help services or inquire about weekly workshops hosted by CLA SoCal and PLC. It should be noted that most cases, well over 90% of them, settle, meaning both sides agree to settlement, usually some kind of payment arrangement, that will lead to a dismissal of the case. Typically, when the parties settle pursuant to a settlement agreement, the case will be conditionally dismissed, meaning that if one of the parties fails to comply with the agreement, the other party can bring the case back to the judge for further orders. Be sure to have any settlement in writing. Know that settlement can happen at any time. You can settle before filing an answer or at any time later, right up to the date of trial. More on settlement in the following videos. The time until trial can be used by both parties to engage in an important part of litigation called discovery. Discovery is the formal process whereby each party requests information and documents relevant to the case from the other side. This is where parties start to build their cases and to determine the strengths and weaknesses of their own case. Discovery will come usually through the mail or process server from the opposing counsel. Do not ignore this. You will have 30 days if personally served or 35 days if mailed to you. Do not procrastinate on answering discovery as these can be time-consuming. More on discovery in the following video. For now, just know that discovery must be answered in a timely fashion. Do not ignore this. Discovery continues until 30 days before trial. At this point, your case should be ready for trial. Please review the trial preparation video for more information on preparing your case for trial. In conclusion, your case, should you decide to answer, will end either by dismissal, settlement, or judgment, either default or verdict by jury or judge. Please review the other videos in this series for more information on how to answer a lawsuit, overview of discovery process and motions, settlement information and common strategies, and finally trial preparation. Community Legal Aid SoCal envisions a world where equity and justice are not a goal but a given.